Okay, let's get going, and then people can just join as and when they're ready. Next slide, please. So, good morning, everyone. My name is Anna Maria Lemmer, and I'm a Senior Associate Solicitor at Ridouts. And today I'm going to be talking to you about inquests and the inquest process. My presentation today will be about 30 minutes, so there'll be plenty of time at the end to ask any questions that you might have. And you'll be able to ask questions by popping them in the Q&A box, which should appear on your screen. I won't answer the questions as I'm going through the presentation, but I will answer them at the end. So anything you want to discuss, just make a note of it and we can run through it together. Next slide, please. So by the end of this morning's session, you should have an understanding of the purpose of an inquest, when an inquest will be heard, how to prepare for an inquest, what is meant by interested persons and being a witness at an inquest, attending an actual inquest hearing, the various conclusions that can arise following an inquest, and finally, and perhaps most importantly, the impact that inquest conclusions can have on a service. Next slide, please. So an inquest is an investigation into a person's death. And the purpose of the inquest is to answer 4 questions. So for the coroner to answer 4 questions. And those questions are: who the deceased person was, when the deceased person died, where they died, and how they died. So they're the 4 key questions that the coroner is concerned with. And in Article 2 cases, the state has a duty to carry out an enhanced investigation into a person's death. So they have to consider the wider circumstances surrounding a person's death. So by Article 2, an example of this is where a person dies while they're in state custody or state detention. So for example, a person who's detained under the Mental Health Act. So they're the kind of situations when an Article 2 case would arise. Next slide, please. So an inquest is a fact-finding exercise. It's an inquiry to establish the facts surrounding a person's death. It's not to apportion blame, and it's not to suggest civil or criminal liability. That's not to say that there won't be civil or criminal issues that also arise in relation to a service user's death, but the inquest process itself is not going to be apportioning blame. It's purely for the purpose of fact-finding. Next slide, please. So in terms of the circumstances when an inquest will be held, well, a coroner will decide to hold an inquest if a person has died a violent death, an unnatural death, the cause of the person's death is unknown, or if the person dies whilst in custody or state detention. So an Article 2 case, which I mentioned a moment ago, an example of that being if a person is detained under the Mental Health Act. Next slide, please. So I think one of the key things with the inquest process is really to be prepared. There's a number of benefits to becoming involved in the inquest process at an early stage. If you can't become involved early, there's greater control and you're able to manage things a lot better. It reduces the risk of adverse findings. And that's really good because obviously with an adverse finding that arises from an inquest, that can have potentially negative impacts on your business. So if you're prepared, it can help to achieve a good outcome. That said, if there is a negative outcome, you can still take steps to address this. And I'm going to cover that later on in my talk this morning. Next slide, please. So on this slide here are some examples of newspaper headlines in relation to coroner's inquests. I'm not going to read them all out to you, but I'll just pick a few to read out. So the first one being, care home resident was unlawfully killed, rules coroner. Then the next one, care home at fault after Alzheimer's sufferer died choking. And coroner criticizes care home following death of pensioner. So these are the kind of articles and newspaper headlines that can arise. I'm sure you've read them yourselves in the papers, and they're the kind of headlines you want to avoid. And so by managing the process and being prepared, you can help to reduce the likelihood of a newspaper story appearing like those set out on the slide here. Next slide, please. So in order to prepare for an inquest, well, the first thing to do is you within your service conduct an investigation in relation to the circumstances surrounding the person's death. The ideal scenario is if you can do that with someone who is independent of the circumstances. So not the actual staff members who were involved, but someone most likely in a senior role. So the registered manager, or if it's a part of a larger organization, your operations director. So someone who can come in and speak to staff, find out who was on duty, what happened, what steps were taken. So that's a really important task to do right at the outset. It's also very helpful to seek legal advice at an early stage. And what we say is the ideal scenario is to engage a solicitor to deal with the preparation side of things, and for counsel, so by counsel I mean a barrister, to conduct the advocacy. I've said a barrister, but it can equally be a solicitor advocate. But just having that sort of paired approach to it can be very beneficial. Next slide, please. So the benefit of having legal advice is at an early stage is because lawyers can review and analyse the documentation to identify any potential issues. So these are any potential issues that the coroner might pick up on. So if I'm working with a provider and assisting them with preparing for an inquest, what I do is I sit down with them, I go through the service's care records, I look to see if there are any gaps in records. And of course, with any care records in any service, there's always going to be some gaps, but it's about identifying them at an early stage and sort of filling in the gaps. I don't mean actually filling in the gaps, but discussing, okay, why is there a gap here? Is this particular matter recorded in another document? Okay, just because it wasn't recorded, is it a case that you still did X, Y, and Z? So it's just about exploring those issues with a provider or with staff members, so that this can be addressed. And the way to address that would be in a witness statement, for example. So what you would be doing is you would be attaching a certain care record. So, for example, a person's MAR sheet. And if there are any gaps in the witness statement, you would be explaining the reason for the gaps. If managed properly, and having legal advice to help with the preparation, it can help to reduce the risks further down the line, because your lawyer is identifying potential issues and matters that might arise and addressing that at an early stage before it gets to a coroner doing that. So it's a way to address those concerns. Your solicitor can also act as a point of contact with the coroner's office. And that's very beneficial because providers, their staff members are, they have their day-to-day jobs, which are busy, and having to liaise with the coroner's office, it can be quite stressful, it's time consuming. Also, you want to make sure you're providing the correct information to the coroner. So having that legal input and that point of contact can be really helpful. Next slide, please. So on this slide here, it says lawyers appointed by your insurer. Now, I speak to a number of providers who do go down that route. So their insurer appoints a solicitor, and that solicitor acts for the insurers, and that's the key point. They act for the insurers in relation to a matter. So there are benefits to that, and the main benefit being that you won't have to pay legal fees, and that's because it's covered under your insurance policy. So that's obviously, reassuring for providers from a cost perspective. However, there are some potential issues that can arise, and the main one being the conflict of interest point. So any solicitor that is instructed and engaged by an insurer, their instructing client is the insurer, it's not you. And so they do what the insurers want, not necessarily what the provider wants, or not necessarily what's in the provider's best interests. So insurers are concerned about potential claims that they may be liable to settle. So they're looking at an inquest through that lens. With that means that they're not as concerned about ongoing reputational risk to providers, because it really is just about claims and what they might be liable to pay. Whereas if you instruct a solicitor to represent the home or the service, they are purely focused on the organisation's interests. They are considering potential reputational risks and how best to manage them. So whilst it is very important to notify your insurers right at the outset of any potential claims, and you might be aware that a potential claim could be coming if, for example, you receive a letter of complaint from a family member. At that stage, it is important to put your insurers on notice that there's a potential claim. But you might find it's better to actually instruct your own solicitors. Whilst you'll have to pay for that, at least it means that the organisation's interests are fully represented. There's no conflict of interest there. Your solicitor is considering the potential wider reputational risks. Next slide, please. So in order to prepare for an inquest, one of the main things that you can do is to request what is known as interested person status. And this means that you can have more of an active involvement and engage with the inquest process. I'm going to discuss that in more detail in a moment. Another really key way to prepare for an inquest is to prepare witness statements. So, and the best way to do that is to draft statements with a lawyer with evidence and support. So if I'm working with a provider or a staff member and they've been asked to provide a witness statement to the coroner, what I do is I sit down with that staff member, I ask them questions about the facts surrounding the death of the service user, and then I cover off any potential issues. If there are any gaps in records, I'm sure that that the staff member talks about that and provides a reason, and that's set out in writing in their witness statement. Doing those things can really help to manage the process and reduce risks. Next slide, please. So with interested persons, if a coroner does not appoint an interested person, often they do, so they might write to, and I'll use the example of a care home, they might write to the care home and say, you know, the care home has been granted interested person status. This means that they can have an active involvement in the case. But if the coroner doesn't do that, you can request to be granted interested person status. So your company can apply, and it is very beneficial to do that if you haven't been granted inquest process, because you have more of a role in the proceedings and you have access to various information and documentation. So examples of interested persons include the deceased member's family, medical practitioners, so doctors, nurses, the actual care home itself or hospital, possibly CQC or even the police. It covers a variety of people. And interested persons have the right to actively participate in proceedings. So as part of this, they can receive disclosure, and they can also provide disclosure. So by receiving disclosure, an example of that might be receiving a copy of the deceased person's post-mortem report, which can help to shed light on the circumstances of the person's death. And they can also provide disclosure to the coroner, so certain documentation, certain care records that they are going to be helpful. As an interested person, you can also ask witnesses questions, which can again be very helpful, because that's a way of, you know, establishing all the details and circumstances. Next slide, please. So with witnesses are decided by the coroner. Often right at the outset of a matter, the coroner will write to an individual, for example, a registered manager, and say, we would like the registered manager to provide the deceased person's care records and to provide an account of what happened at the time of the person's death. However, you can also make suggestions and supply statements to the coroner. So for whoever you think is best placed to provide evidence. So for example, you know, the coroner might request a statement from a senior leader or the senior nurse on shift, but following you conducting your own investigation, you might actually realize that a care assistant who was on shift at the time actually has some really essential information that would be helpful and beneficial. So you can make a suggestion to supply a statement from that member of staff. Providers can support individuals with witness statements, but ultimately the ownership of witness statements lie with the person making it. Next slide, please. So in relation to attendance at the hearing, it's only required by those individuals who the coroner decides needs to give live evidence. So just because you provide a witness statement, it doesn't mean you'll be actually physically called to attend the hearing and give live evidence. Other statements can be read out during the inquest, or they might not even form part of the hearing bundle if the coroner thinks they're not relevant. For all witnesses, I always advise them to familiarise themselves with the contents of their own statement to remind themselves of what they've said, and other witnesses' statements and other information contained within the disclosure bundle. And just so that they've really got that awareness, they know where all the documents are in the bundle and how to find them should they need to. Next slide, please. So in terms of inquest hearings, there can sometimes be what's known as a pre-inquest review hearing, so a PIR hearing. And PIR hearings take place if issues of law or procedure need to be determined. And examples of that relate to if the coroner needs to decide which witnesses to call, the scope, the length of a potential hearing, whether a jury needs to be called, and to get a progress report in relation to where things are as they currently stand. Next slide, please. So with the actual inquest hearing itself, can be really daunting and scary for staff members. You know, a number of staff members won't have ever been to an inquest, and it's a worrying time for them. So it's really important to be there to offer staff support. I think as well, having a solicitor involvement at an early stage, and having your staff members speak to the solicitor and your solicitor being able to reassure them, that can also be very beneficial. Witnesses should know their evidence in advance, so it's very helpful for them to reread their witness statements and just familiarise themselves with them. During the actual inquest hearing, what will happen is the coroner will call a witness, and then they will either swear an oath or take an affirmation, and the court officer will guide the witness through this. Next slide, please. So in terms of the process, once a witness has given their evidence, the coroner will ask questions first. It's then followed by any interested persons. So that the main example of that being the deceased person's family members. And then it's followed on by the jury if one is engaged. So lawyers can only ask questions during an inquest hearing. There's no cross-examination. So that differs to criminal hearings, for example. Although lawyers can't cross-examine witnesses, what they can do is they can ask certain questions which might cast light on different evidence, and that can be really beneficial and a way of managing the process and the kind of evidence that comes to light during the hearing, which is ultimately going to assist the coroner. It's very important to be helpful and respectful to the coroner, answer their questions, but most importantly, stick to the facts. If you don't know the answer to a question, don't make it up. You can only answer, questions to the best of your knowledge. So that's all you can do. And as long as you're doing that's all you need to be concerned about. Do defend yourself and explain where you have reason to. This mainly applies in relation to questions you might receive from a deceased person's family members. Understandably, they're often very emotionally distressed, and they can ask a number of questions that can come across as quite hostile in nature. The coroner is there to assist those interested persons and family members to make sure that the questions asked relate to the remit of the inquest. So if it gets too hostile, the coroner can step in. But if you are a witness and you're giving evidence, you should feel confident in the evidence you're giving, and do defend yourself where you feel there is a reason to do that. Next slide, please. So moving on now to conclusions. So the types of conclusions that can arise. Well, first of all, they are not called verdicts anymore. So you used to have a verdict following an inquest hearing, but they're now referred to as conclusions. And there are different types of conclusions that can arise. So there are short form conclusions, or there are narrative conclusions. So Examples of short form conclusions are natural causes, an accident, an unlawful killing, suicide, or you can have an open conclusion. So an open conclusion arises if there's insufficient evidence to determine one way or another what led to a person's death and the circumstances surrounding it. With regards to narrative conclusions, well, a narrative conclusion is really a longer sentence which describes the person's death and the circumstances of that death in more detail. Next slide, please. So as I mentioned at the start, with inquests, there is no, it's a fact-finding exercise and it's not to apportion blame. So there's no civil or criminal liability attached. However, sometimes there can be negative wording which appears in a conclusion. So an example of this is A died from an accidental overdose of his medication. He had not been provided. Sorry, I'm just moving my. Was just moving my image of myself off the screen there so I could read it out properly. So yes, he had not been provided with full instruction on how to take his medication. Or another example is B died as a result of jumping from the roof of the hospital. She had clearly been distressed in the lead up to her death. Her carers were not providing the constant supervision she required. So they're the kind of, they're examples of negative wording that can appear in a narrative conclusion. And that's something you really want to try and avoid if you can, if at all possible. Next slide, please. There's also something that can arise is what's known as a neglect rider. So a finding of neglect for the purpose of an inquest means a gross failure to provide basic care to a person. And that person is in a dependent position and the deceased's condition was known or should have been known such that action was required. And this failure had a clear and direct causal connection to the death. Again, this is something you want to try and avoid if possible. Next slide, please. So following an inquest conclusion, there are various situations that can arise and they have different impact. So the first being media interest. So coroner's inquests are held in public, and that means that journalists can attend a hearing and they can report on it. So in that regard, you can have media interest. Obviously, at the start of this presentation, I included some examples of newspaper headlines that we've seen in the past relating to inquests, and it's possible for that to happen. So what you want to try and do is manage the process. Depending on the facts of each individual case, sometimes I advise providers to have 2 press statements prepared in advance. So one press statement which covers the service's position in relation to a potential negative conclusion, and then another one if the conclusion is more positive, but just so that you've got a statement prepared and it's ready to go to the press should there be a need to do that. In terms of another impact that can arise, well, sometimes it can prompt CQC action. And that CQC action can be in relation to an individual service or the wider organisation if that service is part of a wider group. So, for example, if it's a large care home provider with, 5, 6, 7 services, what CQC might do is then go in and inspect all of those services. And an example of this might be in relation to a service user who has died from choking. CQC might go into other services to see if there are any patterns or trends arising, and they're looking at risk management around choking incidents. Another thing that can arise is in relation to local authority action and safeguarding. So this is obviously separate to an inquest, but nonetheless can be quite detrimental and again quite time consuming for providers to have to put resources into dealing with local authority issues. It's also possible for an inquest conclusion to lead to a civil claim. So that might be if a family member decides to pursue a civil claim separately, or it could also lead to a police investigation reopening if new evidence comes to light during the inquest process. It can also lead to something known as a Regulation 28 report. So this is a prevention of future death report, which the coroner has a duty to issue. And I'm going to discuss that in more detail now. Next slide, please. So prevention of future death reports, or PFD reports, they are issued by the coroner under Regulation 28, Schedule 7, and the coroner has a duty to issue a PFD report if they feel that by issuing it, it can prevent a future death arising. Now, a PFD report can be addressed to one party or it can be addressed to multiple parties. So if, for example, a service user died in a left the care home in an ambulance and was admitted to a hospital and then subsequently died in that hospital, depending on the kind of care that was received in both services, the coroner might address a PFD report to both the care home and the hospital. And the party to whom the PFD report is sent must act and respond to the PFD report within 56 days. So, and that's a case of responding and saying to the coroner, this is what we've done to address the issues. These are the lessons we've learned. This is how we've shared learning from those, from that incident with the wider staff group. And this is how we're going to reduce the risk of a future death arising in the future. Next slide, please. So with PFDs, there are risks with them. And the main risk is reputational damage. So PFD reports are publicly available, and the press and media can pick up on them and do often report on them. So the best thing to do is try to avoid one in the first place. And to do that, what you want to be doing is setting out in your witness statements any lessons that have been learned to prevent a death such as the death that has happened arising in the future, and how that learning has been shared with the wider staff group. PFD reports, because they're in the public domain, they're easily accessible. This can be very distressing for service users within the service, and distressing for family members of the service user who has died, and also families of service users who are still residing in that service. They can form the basis for allegations of criminal or civil liability. So that is something important to note. And regulatory enforcement action can follow on the back of a PFD report. CQC will often rely on the concerns raised by the coroner in a PFD report, and they might go in and carry out an investigation on the back of it. Can also lead to potential CQC prosecutions. On a practical level, for a provider, if they have to respond to a PFD report, there are obviously time and cost implications in that, because you have to dedicate a lot of resources to it, and that takes staff away from their day job as well. If you're in a situation where a PFD report has been issued and you've got that 56 days to respond and you need assistance with that, what I would advise is speaking to a solicitor, and they can help because they know the kinds of things that the coroner is looking for, and they can help guide you in relation to that. Next slide, please. So what happens if there is a negative outcome? Well, that can happen, so don't worry. That's the first thing. Don't ignore it. Don't bury your head in the sand. The best thing to do is tackle it head on. So handle any press and public relations carefully. So you might want to engage a PR company to handle the media side of things for you, and they can help with preparing a press statement. If you've got a press statement, it's ready, it's there, it's ready made, and you can email it to journalists and say, this is the organisation's position. So that's a way of handling that side of things. If there is a negative outcome, it is important to prepare for regulatory scrutiny. CQC now is a more aggressive regulator, and they are coming in, they're risk focused, and with that, it can, as a result, lead to more findings of breaches of regulations. So any negative conclusions from an inquest, it's important to discuss that. Again, I keep mentioning what lessons were learned, how has this been addressed, what's been changed, how has this been shared with the wider staff group to reduce the risk of it happening in the future. Do prepare for threats of claims, so civil claims, but don't assume that they have merit. What might happen is, following an inquest conclusion, you might receive a letter from the family member of the deceased, from their solicitor, in relation to a potential claim. But just because they send you that letter, it doesn't mean that the claim has merit. In those situations, it is important to notify your insurer. That is something that they're concerned with. They're concerned with potential claims and liability, so that's something that they can deal with for you. Final bullet point on the slide there, it's about learning lessons, and I've mentioned that a few times, but if you can show that lessons have been learned and steps have been taken to reduce risks and to prevent the future death of arising like that in the future, if that's all set out in a witness statement in advance of the hearing, it can help to relieve the coroner's concerns, and they're going to be less likely to issue a prevention of future death report. Next slide, please. So I've obviously talked about potential negative conclusions, but often there are also good outcomes and good conclusions. So in terms of what a good outcome might be following an inquest, well, the main one is no criticism of the service. So you might have a narrative conclusion which says staff in the home followed the service user's care plan. There were no criticisms of the care staff. That's a kind of positive conclusion that you might read. Obviously, not receiving a PFD report would be a positive outcome, and one where there's minimal cost and effort involved, and no bad press. Obviously, that's very good if you can avoid adverse media interest and press coverage. In terms of minimal cost and effort, obviously it is, if you don't go down the insurance-backed route of using one of their solicitors, there can be costs involved in instructing a solicitor. But what I would say is that the benefits of doing that at an early stage outweigh the risks. And that's because your lawyer is skilled at identifying potential issues and knowing how to address them and how to alleviate the coroner's concerns. So whilst it can be a cost at the start of the process, it can help to produce risks further down the line. Next slide, please. So that today has been a whistle-stop tour of the inquest process. In terms of key takeaways, just remember that the purpose of an inquest is to establish fact, and it's not to apportion blame. It's an investigation into a person's death, and it's for the coroner to answer those 4 key questions. So who the deceased person was, when they died, where they died, and how they died. I talked about the benefits of becoming involved in the inquest process early on, and a way of doing that is to request interested person status. And I mentioned that adverse findings can have a negative impact on your business, but there are ways to help achieve a good outcome. And even if you are issued with a PFD report, it's not too late to instruct a solicitor. They can help you to alleviate the coroner's concerns. And that ties in nicely with the final bullet point in the slide. If there are negative outcomes, you can take steps to address this. So thank you very much for listening to me this morning. I'm now going to have a look in the Q&A box, and I will read out your questions and just see if I can help and assist. So it's kind of family request an inquest. So in relation to that question, it's the coroner who decides if an inquest is necessary. If after carrying out an investigation, sometimes a coroner will just carry out an investigation and it won't go as far as an inquest hearing, but it's the coroner who decides to whether an inquest is necessary. The coroner will also take into account the family's views, and they play a very important role as interested persons, but it is ultimately the coroner who decides. In answer to the question, will this recording be available later? Yes, it absolutely will. We'll be sending the slides out following this presentation, so you will have access to them. And I think we'll be posting this video on our YouTube page, so you can also rewatch the presentation if it's helpful. When care staff in particular are involved in inquests, I found that they are incredibly vulnerable. Often they do not make good witnesses as they are so nervous and trip over their statements. Do you have a guide for practicing how to be a witness at an inquest to give them an idea of what to expect, or videos of what to expect as witnesses? Well, in response to that, I'm always happy to speak to people in relation to the inquest process if they're called to attend as a witness. There's also there's a substantial amount of information available online, which talks about the inquest process and what to expect. So you'll definitely be able to find things on our Ridouts website as well. We contain a lot of information about inquests, so witnesses have an idea of what to expect. So hopefully that helps with that question. And I think that's it in terms of questions. So does anyone else have any question that they want to raise at this point in time? If you do, please pop it in the question and answer box. I can't see anyone typing, so I'm going to take that as no one has any further questions. But if there's something you want to ask privately or separately. My details can be found on the next slide. If we just move over to that slide. So that contains all of our website information, our Twitter page, our LinkedIn page, and our YouTube page. So there are various ways there to contact us. So please don't hesitate to reach out should you have any questions. Okay, so thank you all very much for taking time out of your day to join me this morning. I hope it's been helpful. And like I said, if you do have any questions, please let me know and I will be happy to answer them for you. Thank you. Thanks, everyone. Bye-bye.